Introduce the case record as the Codes Department has it on the wall here by means of a PowerPoint presentation. We'll present any letters we've received in support or opposition to a case, as well as any correspondence received from other government agencies. At the conclusion of our presentation, the applicant will come first to the table and present their testimony along with any persons in support of their case. And if there's opposition, then once the appellants come and made their presentation, the opposition will go next. In cases without opposition, the applicants have 10 minutes to present their testimony. In cases with opposition, both sides, that's both the applicant and the opposition, have 15 minutes in total to put on their testimony. That's not per speaker, that's per side. So if you have multiple speakers, please divide your time up accordingly. All section numbers I refer to today come directly from the Metropolitan Code of Law in Title 17, which applies to the entire jurisdiction of the Metro government. It was adopted and became effective January 1st, 1998, and I'll introduce and make a part of the record the zoning code, a copy of which is at my desk back here, and I'll dispense from reading individual sections unless the applicant or opposition requests that I read them. The code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address the board come forward. There's a speak button on your podium and right in front of you. The red light will come on like my microphone here. Your mic's hot. You're able to talk. When you get done, if you'll just push the button and turn that off, we appreciate it. It should be noted that it's found anyone has presented false or misleading testimony to this board that may have affected the board's decision. Any approval may be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will discuss and vote on that case. The board is vested with the power to act on these cases as outlined in Section 1740-180 of the Metro Code of Law. The code requires that you have 4 members of the 7-member board be present to constitute a quorum. Code also requires that you have 4 affirmative votes to grant your application. Today we have 5 members present, so you need 4 out of the 5 members to vote for approval to gain your approval today. In the event that you do not get 4 votes, let's say it's 3 for and 2 against, your case will stay on our agenda for the next 30 days. It will come up at the next hearing. Those 5 that participated are able to change their vote. The 6th and 7th member would have to watch the record, watch the hearing, and look through the record to become eligible to participate. But after that 30 days, if none of them change their vote and the vote stays 3-2, your case is denied by operation of law. The appellant or any aggrieved property owner may request a rehearing within 60 days of today's public hearing. Further, the applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within the same 60-day period. After that 60 days has elapsed, the board's decision is final. No further action may be taken. If you're an applicant and your case is granted, it is necessary for you to come and pick up the permit for which you've applied. This is just one step in that process of obtaining the permit. And you have 2 years from today's date to pick up your permit for this board's approval to remain valid. If you pick up your permit within that 2 years, your approval is vested, and that approval runs with the land in perpetuity. If you don't pick up your permit, you have to come back and ask approval at a later date. All cases I submit were filed in proper order. Applicants were notified by certified mail as required by the code. All affected property owners were notified by first-class mail, and a legal ad was posted in the Tennessean as required by the code. Before we begin, the board allows elected officials to address the board. So are there any elected officials present who wish to address the board? Mr. Chairman, I see none. Preliminary announcements, I have 2. First, on page 1, case 2012-61, Charlie Mitchell, 7739 Charlotte Pike, was requesting a special exception in the AR2A district on the parcels listed on the agenda for a construction and demolition landfill and accessory recycling collection center. The applicant has withdrawn their request, and that case is no longer before this board. Will not be heard today. And on page 4, case 2012-74, Positive Steps Animal Boarding Facility, the appellant SSV Partners General Partnership at 525 26th Avenue North. That special exception request and variance was for the use of the structure as a animal boarding facility. That case has been withdrawn by the applicant, and it also will not be heard today. Those are the only 2 preliminary announcements I have. Members, do you have any others? Okay. The board has a consent agenda. And prior to today's meeting, the board reviews the record, and in each case where they feel, in their opinion, the applicant has met the criteria for the application that has been requested, and they feel that testimony would not alter the material facts, they recommend the case to the rest of the board for approval. Mr. Chairman, Whitson was nice enough to review today, and when I call the following cases, when I call these cases, if you're here in opposition to a case, please raise your hand, okay? And we'll hear that in its regular order. The following cases have been recommended for approval on the consent agenda. First case being 2012-68, Stony River is the appellant, WPP West End LLC and WE Partners LLC, the owners, 3015 West End Avenue, requesting a special exception to street setback to construct a new covered patio seating area to the front of the building. Is there anyone here in opposition to case 68? Mr. Chairman, seeing none, Mr. Whitson believes the request meets all the criteria for special exception as required by the code and recommends that case to the remainder of the board for approval. We've also received correspondence from Edith Langster, as well as a phone call this morning, recommending approval of the request before this board. And with that, Mr. Whitson recommends that case for the consent agenda. Next case recommended for the consent agenda is case 2012-69. Karen Furlong, the appellant and owner of the property at 252 Haverford Avenue, requesting a variance in the side setback in RS-20 to construct a 21 by 22 detached garage. Is there anyone here in opposition to case 69? Mr. Chairman, seeing none, the exceptional shape and unusual shape of this property necessitates a need for a variance, and it also be noted that the exact same request was requested in 2006 by a prior owner for the exact same structure, and they never followed through, and the property since sold to this owner. They're requesting to start that request up again. The next case is 2012-70, Barbara Stingle and Monica Sterrett at 4110 Nebraska Avenue, requesting a variance in the street setbacks. Are there any parties here in opposition to case 70? Mr. Chairman, seeing none, we did receive a letter from the Neighborhood Association recommending approval of it on that case. The next case recommended for consent, case 2012-71, Mark Andrew Ty, 8405 Rolling Hills Drive, requesting a variance in the side setbacks in R40 to construct a new detached garage. Is there anyone here in opposition to case 71? Seeing none, this case, the unusual shape and exceptional topography are the hardships in which are required and necessitate a need for variance. And finally, case 2012-73, Global Outreach Development at 401 Center Street, requesting a special exception in R8 to locate a 28 by 64 mobile office classroom. Is there anyone here in opposition to case 73? Mr. Chairman, seeing none, this case meets all the requirements of special exception and has been recommended for consent. So recapping, cases 68, 69, 70, 71, and 73 have been recommended by Mr. Whitson for consent.
Okay, so we've got a motion. Have we got a second? Second. Got a motion second. All in favor?
I'd like to add a condition on that first one, the number 2012-068.
Okay.
That the applicant comply with, coordinate with the Metro Planning Commission to ensure, Public Works to ensure a adequate sight line at the access driveway.
Public Works, right?
Right.
No, okay,
right.
Great. Oh, okay. Okay, that's fine by me. All right, so we've got a motion and a second as amended by Mr. King. All in favor? Aye. Any opposed? Passes.
If you're here for cases 68, 69, 70, 71, and 73, your day is over. Your cases have been approved, and you can follow up with the Codes Department beginning on Monday about your permits. Thank you all. All right, Mr. Chairman, that leaves one case before us, and I'll call the applicant in that case. This is an Item A appeal of Fifth Third Bank's the appellant, case 2012-72. Fifth Third's the appellant owner of the property at 5625 Charlotte Pike. requesting item A and CS. They are repealing the zoning administrator's interpretation regarding interior landscaping requirements referred to the board under Section 1740-180. The appellant has alleged the board would have jurisdiction under Section 1740-180A. Members, as we've talked about before, we've shuffled around how we do this case. And I have a discussion at the end of today's agenda before we adjourn. We need to discuss rules and such. But our process has been actually to let the zoning administrator go first. Should he wish to speak to the board, he has submitted a letter into the record. I'll pull up a copy if you don't have one in front of you already regarding his comments. But essentially lay out the interpretation, and then the applicant will come next to
Can I ask a question?
Sure.
Because in CBRE's letter to us, in the opening line, they say we are requesting a variance, and it's up here on an item A, and I'm just, from where I'm sitting, it might be easier as a variance than an item A, and I'm just trying to, I mean, I know, I'm just wondering, is it a variance or is it an item A? Because
the net effect in the end, depending upon the interpretation, will affect whether or not that interior requirement is required at all. If not, then the plan will proceed as constructed. If you rule the other way, then trees will need to be planted subsequently. So
okay, I mean, just from where I sit, it's to me a little less appealing to butt heads with my zoning administrator than to grant a variance. I'm just wondering. It's not. I don't think it's our decision. I'm just wondering with the applicant's choice. I mean, or if it is even their choice. I'm just wondering.
So if we do decide that the administrator was not in error, then they could still apply for the
always
variance.
file for an appeal on come
to us for a variance.
Not today, because that's not
Right.
before you. But yes, that's always a possibility.
But they couldn't do a variance today anyway, could they, because of notice, et cetera? Okay.
Mr. Chair?
Yep.
The applicant requested that this be an item A. We discussed the ability for him to go the variance route, and he specifically asked that it be an item A, so we were glad to accommodate him with that.
No. I don't doubt that the office has made. I guess I'm just trying to announce up front. But anyway, I hear you. Okay.
Okay. Mr. Chair, would you like for me to just give a very brief overview?
Please, thank you.
Okay. Fifth Third Bank, the applicant, submitted a landscape plan to the urban forester to construct this bank. And in that landscape plan, it depicted an area of parking. Next to the area of parking, there were 2 trees that were supposed to be planted to provide shade for the vehicles that would be parking in this particular area. Federal law, as I understand it, requires banks to also submit lighting plans where they have to show how bright their parking areas are and their lighting areas are for safety type reasons. I took a look at those federal laws, and they specifically address lighting areas around ATM machines. In this particular case, the ATM machine is located on the opposite side of the bank building than the parking area where the tree was supposed to be planted. The long and short is they submitted a lighting plan that showed a light in a particular place. It also submitted a landscape plan that showed a tree in the same place. So we have inconsistencies in the plans that were submitted. The landscape plan was approved as complying with the landscape requirements under the zoning code, and there's been a deviation from that. A light was actually constructed in the place where the tree was to be located, and the tree was moved to a different location. With that being said, I'd like to hand it over to Stephen Kivett, who's our urban forester, and he can elaborate just a little bit further on that.
Can we see a copy of that, of the site plan you're talking about? Because I'm assuming the one that's in the package.
Yes, I could actually send the correct one around. Okay. This is the actual official one here.
Okay, thanks.
Very similar to one you see on the screen. I can't really add anything to Bill's comments, but that was the submitted plan. There was a discrepancy with their photometrics plan and the landscape plan. This is not an uncommon thing, so we're kind of looking for some guidance from the board on this. That's why we brought it up here.
And, Mr. Chair, just let it be known that we're not taking a hard-line position on this. Just wanted to let you all know the applicant asked that this be an item A, and the only reason it is because he requested that we handle it that way. So we're not taking a hard position on this. It's my understanding the tree was planted. It does meet the tree density units for the lot. The tree was planted in a different place. It's just that it didn't comply with the approved plans.
So that's the decision that that is being challenged, is that, or I guess I can.
Well, the interior requirements are not being met either. This would be a departure from what has been interpreted in landscape ordinance for the last 12 years.
Okay.
Okay, unless we have any other questions for then applicant, would you proceed if you would?
Mr. Chair, before you go, I think it may help everyone. Let me show some photographs that I took.
Okay. Oh, I'm sorry, Joe.
It's all right.
And is there an as-built? Not yet, okay.
Let me just go through the photographs for purposes of record. This is the bank property as seen from Charlotte Pike, looking into the site. The area in question, when looking at this photograph, will be to the right-hand side of this building and adjoining properties. It would be these areas in which you notice here, these light poles that have been installed inside the parking lot on the western side of the property, and these are the two areas here at the rear of the building and along the front where those trees on the landscape plan which you saw are required to be, rather than the light pole. So I'll leave those two up for you. With that, I'll turn it back over to you, Mr. Chairman.
Okay. You ready for me?
Yes, please.
Okay. As described, this was
Excuse me, could you state your name and for
my name is Eric Coffey. I'm with CBRE. We represent Fifth Third Bank. Our engineers, though the same company, had two different people working on many aspects of the site plan. So apparently the landscape person who worked for the engineer didn't coordinate with the person who did the lighting plan. We would have much rather had this discussion a year ago than last month, but it didn't come to light actually until we were building the exact same branch in Madison that this whole thing came to light. So I began early on trying to get in front of this, but in the end, the bank is required to maintain these photometric standards, and the lights were by default installed long before the landscaping was. So that's the part that we're trying to negotiate. As it relates to the photometric standards, the banks are required to have a certain amount of illumination around the ATM and the night deposit. The banks have to sort of develop a central set of standards that they can apply over their footprint. So not only are there ATM requirements, there's also parking lot requirements in other states. So they've rolled that into their overall plan. So the bank's plan is to have not only the photometrics around the ATM, but also in the parking lot. And clearly, having a tree where a light is going to shade a significant portion of the parking lot on your way to the ATM, which, if you get into the weeds with the Bank Security Act, would obviously foul the photometrics as required by that set of standards. As it happens, we just got the as-built back from our engineers on the one in Madison. Sadly, we failed that one for almost the identical reason, but different. There, we did not put lights in the islands, and we did put trees. And we've got, if you want to show this around, in the front of the building, the numbers in red are where the illumination did not meet the bank standards, and it's all across the front of the building, all the way around until you get to the ATM. So there, we've got now a new problem, which is we don't meet the Fed guidelines for that illumination, which is why we're here today. Here we do have the lights in the island, but no trees. There we've got trees, but no lights, and a failed photometric. I also would like to bring up one other thing, which is maybe not all that relevant, but we spent a lot of time and money saving the existing trees on the site that are well beyond the required landscape. We got no credit for that, which I can understand, but they are alive and well and much healthier than the stuff we just planted. So, if you'd like to consider that, I would like to give you these pictures, and they also show up in your pictures as well. So again, we're not trying to shrug the cost of the trees or the requirement for the trees. It's just we can't have a tree and a light in the same place, and that's where the conflict is. But those trees were relocated elsewhere on the site.
So have you already determined you'll have to be here for the Madison branch as well?
Depends on what we want to do there.
Okay.
It depends on what we need to do to get that illumination back up to specs.
So what is the issue with the tree? I don't have that particular code in front of me, but you said you can't have a light and the tree in the same place, and that you relocated some of the trees. So it's not a density issue; it's an actual location of the tree issue?
Exactly. The requirements call for a tree to be in that landscaped island. So obviously, if there was a tree the size that is required by the code to be there, it would obviously shade a significant portion of the parking lot when the lights are on. Right.
Okay, so as I see it, what we have to do in these item A appeals is that, and the administrator said that they're not really taking a hard line, so I think we're looking for a solution. So it would, from my perspective, it would seem difficult to find that the administrator or the forester, either one, were in error in their decision. And I don't know that I haven't heard a good claim that they're in error. So I guess what I would like to know from you is what would be your solution to this case so that the administrator and the forester can use that as guidance in future cases?
Well, I've not jumped into the weeds with a variance versus item A. Their interpretation is correct. And what they've said is they're not taking a hard line on this. So what you're being asked to do is allow them to allow me to move these trees and go against their recommendation, which is the trees have to be in these islands, which is what we all agree.
Well, that, and that may I think that would be a variance, and I'm not, that's your prerogative, and I'm not saying that that you should go that way or shouldn't, but I may have heard you say, and I don't want to put words in your mouth, that that since you, well, I don't know, I'm not sure how you, I'm sorry. If you're admitting that they weren't in error, then how can we vote in your favor, I guess is what I'm asking.
Dave, you and I are looking at this the exact same way. I am loath to say that either our administrator or our forester acted in error, because I think that sets a precedent. On the other hand, if this were up on a variance, I can see where we would determine that it's perfectly fine to have lighting in accord with federal law and in accord with safety. And so the reason I was asking if you're coming up with Madison is because if you are, seems to me, as a simple man, we could bring them up at the same time, and I don't know if we even have the power to do this, but credit your fee for the item A towards the future variance fee. I don't know whether that works for anybody.
I frankly don't know all the nuances, and I don't pretend to know. As I understand it, all you're doing is simply overruling their stance on this decision, and with their concurrence. They have to have they can't go against your wishes. They have to have you stand here and say, okay, we heard you, and we're going to allow them to do this.
No,
And that may be a variance in technical terms, I don't know. This was an easy way for everyone to get past this without them going head-to-head with the rules they need to follow. And we got it, we understand it. We would much have rather had this conversation 6 months ago when this first came up, but none of us saw it.
I agree with Chris and David that basically, yes, we do have the power to overturn the zoning administrator, but you yourself admitted basically they're right. So how can we overturn them if you say that they're right?
And let me add this. I believe what we're saying is that under item A, we have to determine that zoning was an error, and we don't have that basis before us. Separately on a variance, the variance is a separate standard of review.
And this may sound like angels on the head of a pin to you, but we're a quasi-judicial board, and therefore what we decide can be used as precedent before. And what we're worried about is that 6 months somebody comes up in front of us and says, well, in this case on this date you cited, and it's thrown back at us. And so it does matter to the board's integrity, even though it may sound like angels on the head of a pin to you.
So I think that the option may be it's a procedure to withdraw and come back with a request for a variance at the same time, perhaps as you make, at your choosing. Either it's your choosing to continue today.
Well, I do have sort of a gun to my head.
And what I think what we're saying to you is that, in all candor, we're required to find that the decision was made in error, and it was not made in error. That's a separate standard of review if you come back to us and ask us for a variance.
I'm happy to do that as long as someone is happy to extend my my temporary certificate of occupancy.
I'm sure that the administrative side of things could work out that. And I'd like to just opine for a minute, and I'm directing this toward our council. Can we, under the standard, take into consideration issues that the code may not have foreseen or addressed, like an unusual, I say unusual, it's unusual for our code that there's a federal standard that must be addressed that is and anyone on the board can jump in on this too, that might come into conflict with a local code such as ours. In other words, he correctly made the decision, but he could only make that decision.
That's a scenario that pops up from time to time, not only with the Board of Zoning Appeals, but with other regulatory boards as well, where there are standards of regulation that seemingly are in overt conflict, and boards have to make the determination which to follow. Now, I should have prefaced my response to your inquiry by saying that I never presume that any section of the Metropolitan Code of Law is deficient in any way, having been passed by the Augusta Metropolitan Council.
No, I think it's the federal law that's deficient, perhaps.
In all likelihood, that is precisely the case, since they don't sign my paychecks. However, to kind of the underlying tenor of your question, this case presents us with an opportunity to utilize a different standard of review, and I think it's what Ms. Garrett actually very eloquently pointed out to the applicant, and really for the benefit of the board and all of us who work with you. The different standard of review puts us in a better position to be able to examine this unique conflict or apparent conflict between federal and local law in a manner where we can bridge the gap that seems to be in place. It's just that with the item A appeal, was the zoning administrator incorrect in his interpretation of the law? It seems that most of the board members have expressed the opinion that that's not the case. And so to the extent your question is, hey, do we have a mechanism? In this instance, yes.
Yeah, under item A. I mean, I know
under item A, it doesn't appear to be the case.
So we cannot take that into consideration. We would be wrong.
Again, it's just a matter of what is the standard of review for you on those cases.
I don't think we would be wrong in taking it up, but the applicant may not get the decision that he wants. To me, it's clear that what Chris said about setting precedents, our late zoning administrator, Sonny West, pictures on the wall of this wonderful Sonny West room over there, used to always tell us, after we would overturn him on something, he would kind of change the way he would look at something because of our ruling. And so I think this is a more appropriate case for a variance, not that we want to keep our new zoning administrator's perfect record of not being overturned by us for now. But I really think that when you talk about variances and you talk about item A appeals are special and unique. And as Chris also said, they kind of have some more judicial weight than us giving a variance off of one particular land and one particular scenario.
If I could interrupt, I'm beginning to get the picture, and I think you're right, because I don't think his interpretation was wrong, and I don't want it said that way. If you're willing to overturn his decision, that's one thing, and that sounds like a variance. So if we're all on the same page here, I think I'd like to withdraw and reappear with a new check.
Can I ask a question first? Do we have the ability or the power to grant the temporary CO until he can come back on appeal?
Absolutely.
Okay. Okay. Then I don't think you're withdrawing. I think we're making a motion
No, we'll handle it. We'll withdraw it administratively and refile it. There's no new check. It's came before you the wrong way. We'll just refile it because when he refiles, it's at the next hearing anyway, where we fall in the cycle. So.
Okay.
Mr. Chair, I think we can administratively agree to keep his temporary UNO in effect.
Okay.
And we will agree to do that.
Okay, and so he is withdrawing effectively?
Yes.
Okay, great.
So for the record, the bank can continue to operate in that facility, and there's no kind of penalty if they do.
Right.
Very good.
Okay.
So ultimately, it looks like that to prevent this case, these types of cases, banks, trees, lighting, from coming back, that if you're looking for a precedent or a way to change the way you look at these, it's legislative at this point. And unless you have an internal policy and then someone challenges that.
I think this is.
So
So
thank
does this
you.
panel not have the authority to change it from an item A to?
No, because we're required by law to provide notice. On a variance standard. So we'll withdraw it. It's at our fault or expense, so there'd be no charge. We'll just refile it. We'll actually keep the same case number and everything for continuity's sake, and it'll come back up at the next hearing.
We'll see you soon.
Thank you very much. Appreciate it.
And what's that? With that, that's actually all of today's business, and thank you, sir, for coming. I do want to talk to you. Our next meeting coming up at the it'd be the third Thursday in August coming. I ask each of you independently, please pull off your rules from the BZA website or from the clerk's office. If you don't have one, I'll get one to you. We need to go through those and update them. They are dated. In many ways, it lists our meeting places out at Southeast when we used to be out there. So we last filed them in 2008. There's not a requirement to file them annually, but it's time to renew them. If there are any other things, and I'll talk to the other two members individually about, but if there are any other rule issues, procedures you would like done differently, time constraints, any of our processes inside this room that you all want changed, please think about those and let's talk about those at the next hearing. Again, I caution you, John will too, you do not discuss it amongst yourselves at all. Don't even discuss it with me if you'll just bring those ideas forth.
So we don't submit them to you beforehand, so if there's an agenda?
I think you could probably do that just fine if you wanted to send them directly to me. I may send you all an email saying, hey, if there are any changes you are proposing, please email them to me. But I won't email you in a mass group. It'll be individually. So that way we don't run into a reply all.
And if I may jump in on that advice as well, for members of the board, this sounds very particular, and forgive me for that, but don't reply all on your emails when Joey sends you anything on this. If you reply all, you're technically discussing board business outside of a public notice scenario and thus violating the Open Meetings Act. If you need to send suggested rule changes or other comments or inquiries to Joey, to me, to Mr. Herbert, to anyone else, just reply to us directly, any of us. We'll be glad to field that.
And at the August meeting, basically I'll bring whatever comments you've submitted along and present our rules to you. It'll be on the agenda, and I'll put forth proposed changes by whichever member's proposing them, and then you all discuss in chambers that. We'll come back, whatever changes you want to make at the following hearing. Final version, is this what you want, a yes or no, vote it, sign it, and file it with the clerk. But there are some things that we would like to change as the Codes Department, just some housekeeping type things. But if there are any other process or procedural changes you all want as a part of your rules.
Okay, and you'll make this public and notify, and we'll meet.
Absolutely. The requirement for us is 10 days notice to the public that we will be discussing your rules. That will be accomplished by the legal ad as well as the agenda posted on our website for August's meeting, which I haven't posted yet. We're just now closing that agenda.
The rules themselves will be?
The rules themselves.
The proposed rules that we're saying will be posted?
Yes.
Or?
Yeah. Our current rules are out there on the website now and filed with the clerk. But I'm asking you all individually of any changes you wish to make. We have some that we need to update from a procedural.
I apologize. So we don't have a meeting on the 2nd. I haven't checked the website.
We don't.
Yet. Okay.
August 2nd, I don't have a meeting. That's the general primary.
It's my birthday.
And it's David's birthday, and that's why we're not having a meeting. But we won't have a meeting that day. This room is tied up for election business, so we'll be back on the 16th of August will be our next meeting. But if you don't mind, if you'll email me individually, any changes, even minor, however minor, just please send them on, and I'll write those up for you next time. Okay?
Otherwise, we're adjourned.
All right. Board of Zoning Appeals is adjourned. Thank you all.